Okay. So I am recording, and for everyone on the phone, I don't know if you're new or not, but my name is Jen, and we have Eric and Daniel on the call. We are 3 or 4 that run AppliedAI, the meetup. We've been doing it for just over a year now. We used to be IoT Fuse, the meetup. And our whole goal, if you're unaware, is to help mostly the Minnesota or Midwest community become more educated or get resources that they'd like in the AI space. And so meetups are one part of what AppliedAI does. Justin Grammons also leads our podcast. So Ryan, I don't know, I think he also talked to you about that.
Yes.
So we have a cool podcast. And then as we hopefully get a little farther away from COVID times of everything being virtual, we'll start up. We have like a hackathon, which is called the IoT Hack Day, and other things in person that are like learning experiences outside the meetup. So that's the background on us. We have our first meetup, or our meetups every first Thursday of the month. And I think we'll end, Eric, I'll probably have him talk about that at the end of this presentation. So we have that to look forward to. And then Ryan, thank you for taking the time tonight to present on this. And if you want to give kind of the high level overview and talk about yourself as well, that'd be great.
Okay, thank you. Thank you, Jen, and thank you, Eric. And thank you for everyone participating tonight and then also watching later. It is May 6, 2021. My name is Ryan Phelan. I'm a partner at Marshall Gerstein, which is a firm in Chicago. So I can claim that I am part of the Midwest community of AppliedAI. Tonight, I'll be presenting on artificial intelligence, AI, and the intellectual property landscape. So kind of a mashup of AI and IP related issues. I prepared a slide deck with hopefully some fun topics in it, just to, because it is later in the night, we want to have fun, but we also want to learn some stuff too. So it'll have a learning aspect in it as well. This is just my contact information and a little bit about me in case you want to get in contact. Feel free to reach out. The telephone number, email, and I'm also on LinkedIn as well. Real quickly, I have a computer science background. I worked in the industry before at Accenture. I filed hundreds of patent applications in the computer science and electrical engineering space, including in AI and related technologies such as IoT, big data, other computer architecture and networking and the like. Again, I work at Marshall Gerstein. We're in Chicago. We're actually in the Willis Tower, formerly known as the Sears Tower. This is a slide demonstrating some of our clients that are in the AI and electrical space, including Google, Amazon, Emerson, and others, underwriting laboratories, and then also some more Fortune 500-ish companies that are not typically considered in the electrical space, such as State Farm, but are nonetheless using technologies such as AI, which we're seeing more and more of today. We have received numerous awards. We've been around since 1955, and we serve all types of clients in technical fields, including computers, biotech, chemical, and whatnot like this. Here's some experience, a few of the things that my firm have. We share. We have experience in machine learning, cognitive computing, deep learning, IoT, big data, cloud computing. We actually have a webpage on this. If you're interested in learning more, you can go to marshallip.com/artificial intelligence. So what will we talk about tonight? Here are the 5 topic areas that I want to cover. Hopefully the first one will be fun. We'll talk about something called the Davos Initiative. Can an AI be an inventor? Can you list an AI, an artificial intelligence, as an inventor to a patent application? Then we'll get into some statistics of AI, an overview, and IP trends. This will help to hopefully align the audience on a definition of AI. And then we'll get into more of a technical discussion on clean drafting strategy for patenting AI-related inventions. And then finally, we'll see how the US Patent Office is treating AI-related inventions. And then we'll talk about other legal forms of protecting AI, such as copyright and trade secret. So with that, I'll jump into the meat of the presentation. So first, we'll talk about the Davis Initiative. Can an AI be an inventor? So I'm not sure if the audience has heard about Davis before. It's a popular topic in the IP community, at least because it asks the fundamental question of whether an AI can be an inventor. Davis was invented by this gentleman. Davis stands for Device for the Autonomous Bootstrapping of Unified Sentience. And I'm not sure if you're trying to stretch for that acronym or not, but nonetheless, it is named Davis. And it's significant because what Dr. Stephen Thaler, who is pictured on the right, what he did was, instead of naming himself as the inventor on the patent application, which I'll show you in a minute, he actually named the AI itself as the inventor, which is kind of the first of its kind to have this. Usually what you want to see on a patent application is you want to name a human inventor. And because he did this, it created all kinds of issues with the patent filings. And he did file patents around the world in multiple patent offices, and they all reacted in a similar fashion, which we'll see in a moment. So what you're looking at on this slide is the PCT, or Patent Corporation Treaty, patent application filed with the World Intellectual Property Organization. This is the front cover of that patent application. It has some very unique information on it. And perhaps the most unique is the item number 72 that you see in on the middle of this slide, where it says inventor Davis. The invention was autonomously generated by artificial intelligence. Now, typically what you would see in that inventor category is a human, like somebody's name, such as John Smith, or something like that, and it would list their address of where that human inventor was located. Here, the difference is the inventor listed as Davis, which is not a non-human; it's an AI, an invention invented by the applicant Stephen Thaler, which you see in the top of the middle of this particular slide. And what this particular invention is about two things, and this is odd in and of itself. Most patent applications describe inventions usually with a singular focus. This one was directed towards two things, and one of them was a container for use for beverages, so just an ordinary beverage container, and the other one was a device for attracting enhanced attention, or the strobe device. And I'll show you examples of each of these right now. So here is the first one, and this, keep in mind that this was invented by an artificial intelligence, a computing machine, where it's not mentioned in this slide, but the computing machine was a series of these neural networks that were fed quote unquote noise, and the noise was problems of the world, for lack of a better word. And the creating machine, or Davis, came up with ideas about how to address these particular problems. And so what you're seeing at the bottom in figure 6 is a beverage container. It's an oddly shaped beverage container that has all of these fractal elements, as they call them, or these ridges that you can see along item 12 there. And what the computer did, what Davis did, is identify at least two advantages for this particular beverage container. One of which is to increase the surface area of the beverage container. Compared to a standard beverage container that would have, a circular design, you can think of an ordinary drinking glass or a coffee cup or something like that. This one has these, if you look at the left-hand figure that looks like a snowflake, it has all of these different angles on it, and this increases the surface area, the subsurface area of this beverage container, and that allows the contents of the container to become to heat up or cool down faster. The Davis provided in the patent application. A second thing that this particular shape of the container allows is it allows the attachment of two containers, and what you're seeing in figure 7 below is that you can attach two of these containers together just by sticking them side by side. And what this does is again, according to Davis, is eliminate the need to have some type of inter-engagement or additional tie elements. We can all think of our 6-pack of Coke, at least back in, I guess they still use it, where they have the plastic rings on the top, and how we were all told that those were bad because when they're thrown away, they can, harm sea creatures and stuff like that, which is, true. And there's been scientific evidence of that. And that's exactly what Davis identified. And it was able to say that the sticking together of these two beverage containers without requiring those tie elements provides an advantage over existing technology that may require some type of tie or other waste product. So that was one example of Davis's invention directed towards the beverage container. The second invention that it identified was this quote unquote neural flame device for attracting enhanced attention. And so what this device did was it's nothing more than a strobe light that can be used to attract attention, let's say at night. But the difference for this particular strobe light is the pattern at which the strobe light strobes, for lack of a better word. So there's an LED component at the top of the light, which is item 6. It can be activated in a manner to, quote, trigger the brain's innate ability to filter sensory information. And if you read the patent, it says something to the effect that as humans, our minds are wired to identify certain patterns in nature more so than others. And what this neural flame device does is it tries to imitate the most recognizable pattern to our brains as humans as possible by strobing at particular intervals. And so the advantage is that you could have one of these strobing devices even in an environment such as a city that already has a bunch of lights in it. And this strobe device would be an enhanced means for attracting attention to humans, because it would simulate how our brains are wired to notice things in the wild. And so again, this is identified by Davis, a machine, and not a human. And under the patent law, this is important because to be a quote unquote inventor, you have to be someone that contributed to the conception of an idea with at least one claim element. And so because there was no human inventor that did that, there's no human that contributed to the conception of at least one claim element, then Davis had to be listed as an inventor. So says Stephen Thaler. And so what happened when the patent application listing Davis as the inventor was filed? So here's an example from the United States Patent and Trademark Office. And this is the outcome of what happened when Stephen Thaler filed his patent application listing Davis as the inventor. As you can see here in this slide, at the very top, we can see that the petition was denied. And this decision came out in July 29, 2019. So roughly 2 years ago. But basically what the patent office said is that you failed to list a quote unquote inventor as defined by the law. And they kept asking for Stephen Thaler to list a human inventor, but there was none. And so they denied the petition, saying that it was defective. In this slide, you can see the language from the USPTO. Exactly, I copied it from that particular decision. And they say, quote, because the above identified application names a machine, Davis, invention generated by artificial intelligence, then as the inventor, and because the current statutes, case law, and USPTO regulation and rules limit inventorship to natural persons, the above identified application does not comply with the statutory code. So they denied the application based on statutory grounds. And here's one of the big ones that is often cited in the legal world is 35 USC 101, which is one of the first statutes in the patent law. 35 USC is our patent law in the US. And it starts off with whoever invents or discovers, right? So whoever suggests a natural person, the USPTO reasons. And there's other case laws such as 35 U.S.C. 115 that refers to uses of pronouns as natural persons, et cetera, et cetera. And after the USPTO looks at the statutory language that seems to be directed to humans, flesh and blood humans versus machines, they come to their decision denying the ability of Davis to be listed an inventor. And so that the USPTO is not unique in that. What you're seeing here is a chart from my blog called Patent Next. I wrote an article about Davis and patenting inventions around the world. And other patent offices, when Mr. Thaler filed his patent application about Davis in those jurisdictions, which include the United Kingdom, Japan, and China, they all came to similar conclusions that their laws, which are different from US laws, they each have language in them where an inventor must be a natural person and not a machine. So moral of the story is right now, patenting at least is left to humans. If we're going to have an AI inventor in the future, that will most likely require a statutory change in the various countries. But I provide this example with Davis just because it's intriguing that, as we sit here now in 2020, we are at the stage where AI, or at least an AI-related machine, can in fact invent per what it means to invent under the laws of the U.S. and various countries, but they just cannot invent because they can't be a quote unquote inventor in the eyes of the law. So it's interesting.
Ryan, can I ask? I'm
Sure.
sorry if this is obvious, but is his name Steven? I think that was.
Yes.
If he had listed himself as the inventor, would they have approved that? I think you touched on why he didn't, but could he have, and they would have accepted that? Like he invented Davis, which invented.
Yes, he could have listed himself. He might have also gotten in trouble by doing that though, because you could depose him later on and say, did you actually come up with this idea yourself? And
that's probably why he didn't initially do it.
In fact, he has told the world that's why he didn't. He said when you file a patent application, you have to sign a document that says something. It's called an oath or declaration, and what you're basically saying is, I declare under penalty of perjury that I am the inventor of this technology. And so, if you didn't invent that, your creativity machine did. You could end up perjuring yourself, which he said that's the reason why he did not do it. Now, of course, the real reason why he filed these things is to bring up the very issue that we're talking about now. He wanted to spark the debate. This was done by himself and also in conjunction with a group that he's a member of. And so the reason why he filed these various applications around the world was, I think, and I suppose it was so he could be the first person to do this. So it's kind of also like a social, interesting social experiment, so to speak, as well. But it did, obviously we're talking about it now. Many other presentations have done so before. And it's quite interesting to see, what rights AIs have. Because right now, as the law is written, it's not that the law is trying to keep AIs from having rights. It's just that they never really contemplated it yet. And it's quite common in laws around the world that they tend to lag reality, especially in the computer arts, by a good 10 to 20 years. So.
Yeah, thank you for clarifying. I think that's what maybe I was trying to get at, is it felt like he didn't just happen upon this issue and was like, oh, I didn't realize. And so I was wanting to clarify, like, why didn't he just attempt to put himself? And so that helps with the context of knowing this was intentional.
Yeah, I think so. I think 100% that's right, that it's intentional. But it creates an interesting talking point, and just wanted to include it here tonight to the extent that it was interesting for the audience. So next topic is artificial intelligence overview and IP trends. This has to do with a high-level overview, hopefully fun, and some statistics as well. So hopefully easy to digest too. So hopefully the next slide is fun, some fun movie posters. And this slide is basically to juxtapose what we just talked about, AI with Davos, which seems interesting from the perspective of, hey, if an AI can quote unquote invent patent applications and whatnot, what else can they do? And a lot of times in pop culture, and even in modern day times, there's a question of like, what can actually AI do right now? And we have a sense of what AI is. A lot of people do from the movies that we watch, right? So we like to be entertained. We like to watch movies, and here I have on the screen a popular set of movies that we probably all have seen or at least heard about. And these are good examples of what AI is not yet. So each of these movies, going back to the 1970s, beloved Star Wars and so forth and so on, show and depict AI as what experts call an artificial general intelligence, or an AGI, which is what we think of as a equivalent to human intelligence. So something thinking and acting on the same level as a human. So right now, as we sit in 2020, AI is really not that advanced, even though we're seeing amazing breakthroughs and things that AI can do. AI is typically limited to specific tasks, and those specific tasks are things that the AI related model, let's say, is trained to do. And we'll see an example of that momentarily. And another example that's very popular is Google's AlphaGo, which was trained to play which was trained to play Go, the game, and bested some of the Go masters of the world. But I mean, if you asked AlphaGo to do anything else, such as drive a car, you'd probably end up with a disastrous result because it was not trained to do that. AI experts polled about the topic of when will we get an AGI that can do the various things that we see in the movies. They say 50% likelihood in 45 years, and that's a very rough guesstimate. So we're still on the very nascency, so to speak, of having an AI as we imagine, or at least some envision the movies. So hopefully that was a fun slide to illustrate that. Another fun slide to illustrate this point is Mr. Alan Turing's Turing Test, also another well-known gentleman. Mr. Turing came up with this test in about the mid-1900s, and he said that the Turing Test is a test of machine's ability to exhibit intelligent behavior indistinguishable from that of a human, where if a human was talking to the machine, it would not otherwise know they were doing so. So Mr. Turing predicted that this would be reached, or it would happen in the year 2000. In the year 2021, we still have not gotten to that level. The closest that I have seen that we've gotten to it is Google's Duplex. And there's a fascinating YouTube video about this, where someone asks to schedule an appointment, such as like, would you please schedule me a haircut for 5 o'clock, on Tuesday? And the duo is able to call up a beautician and do this. And the beautician does not know that he or she is talking to the machine, the Google Duo, because it sounds so lifelike. Now, of course, in some instances they do, because they ask a question and the machine is unable to reply. And we're all familiar with this. If you have like an Amazon Echo device, or maybe even a Google Duo device, sometimes you'll get an unintelligent response back. But anyway, this is another example showing how close we are to actual AGI intelligence, but yet at the same time how far we are. This particular slide, we'll start diving into some more specifics of AI, is some examples of the different types of AI that can be used to create artificial intelligence inventions, or just to use in general for programming. And these are the three big categories: supervised learning, unsupervised learning, and reinforcement learning. Supervised learning is by far the most popular category. Supervised learning, you have this input-output relationship where you take in data, you train a model, and then you're able to use that model to output later tasks, such as a value or prediction. The Zestimate that we find on Zillow for home prices is a good example of this. Unsupervised learning is used more so for clustering. It does not require supervised learning, which is matching up the data beforehand. And then finally, reinforcement learning is kind of an oddity of these two, but it is also very powerful in that you can use it to train AIs from the perspective of action, state, reward sequences. And this is where we get the ability to train autonomous cars, robot navigation, and gaming. One of my favorite quotes about what, in fact, AI is actually a quote from Yann LeCun, who's Facebook's founding father of convolutional neural networks, which is a vision-based AI technology. And he defined at least machine learning as a science of sloppiness, which is a really fun definition. I think, I have a computer science background, worked in the field for quite some time, and a lot of times you end up writing a lot of code, let's say thousands of lines of code that would comprise some type of algorithm to do something. Machine learning, what it does instead is kind of flips everything on its head. You take in data, you train a model, which is a black box, and then you feed new data to the black box in order to have an output. So instead of training, let's say, an if then else statement or some incredibly long algorithm to produce a result, you're relying on data to do that. And hence Yann LeCun's quote, it's a science of sloppiness, because you're not having to code every single specific issue that could come up. Instead, you're allowing a model to learn that by training its own weights and passing in new data as time moves on. Here's an example of supervised learning overview of modeling and prediction. And these three steps will become important later when we look at how, in fact, we patent an invention related to this technology. In this simple example, what you see is a data set on the left, and it simply is a data set of information about programming positions, experience levels, skills, and city and salaries. And what we're trying to predict is a salary for a new worker. And on the data on the left, you have your features, which is your independent variables. And then on the right, you have your label, which is the salary, which is your dependent variable. And as you can see, this data is in a tabular format. It's been quote unquote supervised by lining it up. You're going to push this data into a model, and you're going to train a model with a particular AI-related algorithm. And two such examples are on the right. One of which is k-nearest neighbor algorithm, which is a clustering type algorithm, and the other one is a neural network. You could use one or both of these in order to train the model. And then once you have your trained model, you can use it to do something useful. And because this model is trained to with data from programming salaries, you can use it to predict a new salary. Let's say if you have a new employee and they have a certain experience and a skill level, and they will happen to be practicing in a certain city, let's say Chicago or Salt Lake City, then you can determine what that salary should be using that model. And it's important to note that this is in a three-step process, and we'll revisit this later in another slide when we're talking about patenting inventions. But let's just say that you could use that same pattern to do many different other things with. You could train these AI models and incorporate these AI models into medical devices, pharmaceuticals, autonomous vehicles. You can use it for computer vision, natural language, e-commerce, and planning and scheduling by using a similar technique, by training it with the particular data that you're interested in, that your device will use in the future, and by having that model become intelligent by virtue of the data that it's trained on with your particular AI related model. Now let's get into a few statistics, and then we'll jump into the guts of the presentation for patenting. And I just wanted to show you, everyone on the call, these statistics, because they are from well-known bodies around the world that have put out information because of the growing interest in AI. And so this one was not too long ago in 2019, I guess I should say the good old days, when WIPO, the World Intellectual Property Organization, put out this definition or statement with respect to artificial intelligence, is that artificial intelligence is a new digital frontier that will have a profound impact on the world, transforming the way that we live and work in. Oops, sorry, let me go forward. And this was an interesting statistic from that study. They found that the green line is scientific publications about AI-related technologies. Here we have neural networks, support vector machines, and rule learning and deep learning. And what they found, and then the purple line is patent families or patent filings on those. And what they found is that in the last few years, that patenting of AI-related inventions, with the possible exception of rule learning, has been increasing exponentially. This chart does a great job of breaking that up. What you're seeing here is a chart that shows on the left side a grouping of application types in different industries, such as telecommunications, transportation, security, business, education, etc. And then at the top, you see the AI techniques and functional fields, such as machine learning, computer vision, natural language processing, and the numbers inside of the cells are the number of filings that have occurred patent-wise. So you can see in the top left with telecommunications and machine learning, for example, and telecommunications and computer vision, those have had an explosive growth in the number of filings. And it's not too surprising given the fact that the telecommunications industry or application field, they tend to have a lot of software-related inventions, which AI technologies fall squarely within, because AI is fundamentally a software related technology. Another interesting study that came out, this one was late last year in October of 2020, was from our own US Patent Office. And what they found was in the 16 years from 2002 to 2018, which is where they take their data from, the amount of AI patent relating filings about doubled. So there's an increase by more than 100%. And we can see that in this chart, which is AI related patent filings in the Tech Center 2100, which goes to computing and computing architectures. And in the particular classes, data processing, artificial intelligence, and then similar international class computer systems based on specific computational models, we see this explosive growth starting in 2012 of AI-related patent filings. And one of the good things about AI-related patent filings is that they end up in a tech center that tends to have a high allowance rate. And that tech center is Tech Center 2100, is computer architecture and software. And at the Patent Office, a tech center is a group of individuals, a group of examiners that have a common background. Let's say Tech Center 2100 would be examiners with a computer science or computer engineering background. And their job is to intake patent applications filed by inventors and look at them to determine whether or not they are patentable for a number of reasons. That can be for obviousness, novelty, eligibility. And what we're seeing, again, for Tech Center 2100, which most AI inventions tend to land, is that you have like an 80% allowance rate, which is for the most part pretty good, especially compared with other computer-related tech centers such as Tech Center 3600, which you see in orange on the right, which has like half of that at 40%. So I'll pause there to see if there's any questions. I know that was a lengthy section on statistics before we get into the next section.
I think we're good in the chat. We just have some comments that I don't know if you were able to see them, Ryan.
I have not.
But Christopher just mentioned that shape initially that Davis had invented looked hard to clean. And then Daniel actually brought up, related to that first story about, it reminded him of a man generating every possible song using software and copywriting them. So just,
yeah, I'm looking at the comments now. I like this. Yeah, I thought so too, and I was thinking about making a joke that that's not the shape of cup that I would want to hold because it looked very spiky. So, apparently the AI machine has a lot to desire for ergonomics, let's say. And yeah, it would certainly be a pain to clean because it has all those different surfaces on it. So, I guess that plays into our earlier discussion about AI is really good at doing very specific things, but not others. I don't think humans have designed a cup like that for at least the ergonomic reasons. So it was interesting to. So that's a very good comment. And then I see another comment here. Reminds me a bit of the story last year. Man generated every possible song. Yes. So, and that's the concern is that maybe we have these inventing machines that kind of invent so much stuff that nothing's left for people. But at the same time, machines are limited, as we saw, based on what they're trained on. So these machines are certainly not AGIs like what we saw earlier. Like that's still a long way off. Even if assuming that the experts are right, 50% in 45 years is that's not necessarily a high probability.
Really quick, sorry, just to clarify Daniel's comment. So if he successfully copyrighted the songs, then does that precedent pertain there? Because he technically, did he generate the songs or did his AI, and then he could copyright them? Because wouldn't you say if the AI generated the songs, then he couldn't own them, or am I wrong?
No, so I think it's a new hypothetical. So Davis invented these patent applications, which are patents and not necessarily copyrights. But if we wanted to change and think about a different question, such as computers simply, coming up with text or rearranging words, then the copyright would have the copyright laws have the same type of problems that the patent laws have in them. They're very human specific. So in fact, there was a case about the monkey selfie. I'm not sure if you guys have heard about that, but there was a monkey, believe it or not. I mean, I don't make this stuff up. There was a monkey that took a picture of itself, and the picture became quite, it became viral, let's say, because it was a monkey and it was smiling and went like this. So it took a selfie. It became known as the monkey selfie. And so the question was, who owns the monkey selfie? Can a monkey be a copyright owner, for example? And the same question played out. It was like, is a monkey a person for purposes of owning copyright? And I kid you not, the courts debated this, and come to find out, no surprise, that the law is written in a way that a human must be a copyright owner, and so therefore the monkey did not have rights in that particular photograph, and it was denied. So same thing would play out for songs if a computer or a monkey, I suppose, tried to write a song, then they would be denied under current law. So yeah, I mean,
on that, I'm gonna look it up because I'm like, sounds like he did successfully copyright them if I'm reading how Daniel worded it. And my question would be like, well, why wouldn't you put something in there then they like invent it, but couldn't you say, and I came up with the color, so I as a human contributed? And then
yeah, you could. I mean, there's a concept of, in the patent world and in the copyright world, there's a concept of joint inventorship. So let's say, we go back to Stephen Thaler, and he came up with at least one claim element, and he put that in there into the patent with, the Davis invention machine. Like Davis came up with, 5 ideas, and Mr. Thaler came up with 1. Then he could have listed himself as an inventor, and had he done so, had that hypothetical played out, then he may have gotten a different answer, because he would have been able to list himself without fear of perjury by putting himself down as an inventor.
And then maybe that would have made it so that AI could be what did you call it?
A joint inventor.
A joint inventor.
Yes.
But his intention was obviously not to actually like pursue that. And it sounds like Daniel's story, they're probably trying to make money, or like the purpose was different, or the goal was different. But
yeah, so in that case, he wasn't actually trying to make money or assign the copyright to the machine. All he was trying to do was copyright, 100 trillion songs, however many combinations there are. And maybe you could do something with patents. You probably couldn't get every possible patent, but you could get millions or billions. The filing fees might be a little bit high. But because you're taking out the human element, you could patent a much wider swath of the available universe of inventions. Good for patent lawyers.
Yeah, those would. I imagine these would be very, very interesting. All those different permutations.
Hey Ryan, question from Eric here. So, what do the IP lawyers think about these machines that are able to draft the patents and think of almost like a crystal ball scenario? Think of 3-4 generations of a particular invention down the road. Is this a good thing for the IP practice or practitioners, or do IP practitioners think this is something that will maybe take business from them?
Yeah, I understand the question. Right now there are some tools that assist in patent drafting, but as far as I know, there's no tool out there that can kind of do it, end to end. So there's still human input. Even the patent application that apparently Davis came up with, it did not spit out the patent application that I showed you earlier. It was crafted by humans after Davis allegedly came up with the claim elements, which is the invention. For all patents, the invention is the claims, and then you have to have a specification and a written description that and figures and whatnot like that accompany those claims. And not all of that was just somehow magically plopped out of a machine. It was just the ideas for the claims, and probably the claims themselves were massaged and edited by a human as well. So we're still quite far off from some type of tool that can just you press a button and all of a sudden you get a patent that gets spit out with perfect figures and text and drawings and whatnot like that.
So Ryan, this is Christopher. On the Davis example, how did the AI sign the inventor's disclosure? You said that inventors have to sign.
As far as I know, it did not sign.
Okay, doesn't that make it ineligible to claim the patent as an inventor then?
Yes, and that's what the USPTO said, is that the Davis as the inventor could not be an inventor because it was not a human. In fact, I think there was some interesting argument by Stephen Thaler that Davis could not sign because it could not, because it didn't have that capacity, and it was incapacitated under the law. It did not have the ability to sign. Yeah, exactly. Because of course, it's a machine trained to do something specific and not sign documents. And so, under the law, there's you can have somebody sign for somebody else if they're incapacitated. And so they tried to make that creative argument there, but it was a little too creative for the USPTO.
Okay, thank you.
yes,
Okay.
sorry, I was gonna say, I think you're good moving forward, and you're doing great on time. It's 7:24, so I think we can do another. I'm trying to think about how long it's been. Like 20, 30 minutes. I don't know how you're feeling on time, but you're definitely good on our end.
Yeah, I think we should be able to wrap up pretty quickly here. I think the slides are moving along. So I'll just jump into this next section, which is actually reasonably short. In fact, we're revisiting the previous slide, as I promised what we're looking at here, again, is a simple example of a machine learning. I'm trying to move my Zoom. There we go. What you're looking at here is, what you're looking at now is our simple example of supervised machine learning, of training a model using a data set on the left with features and labels. The features being information about position, experience, skill, city, and salary, and using an algorithm to do that, to train the model. And then you have this, sort of black box model that you can push new data in order to get a prediction or classification, in this example, salary. And the important thing to note, and I'll flip back to that slide one more time, my apologies, is that you have these 1, 2, 3 steps that are pretty common for at least supervised machine learning, which is the most common type of machine learning. And we can use this pattern in order to draft a claim for a patent. And as you can see on the left here, we have the same 1, 2, 3. And those are the 1, 2, 3 steps that we saw in the previous example, such as the first step is the pre-processing of the training data. The second step is the training process itself to generate the model. And then the last step is the use of that training model. And in our patent claims, if we have those 3 claim elements, we can argue that to the patent office that the claim is technical, and that the invention is the improvement to a computer and its predictability. And we can argue that the computer itself is improved, or that you're controlling a particular machine by use of the model, or you have a projection of a tangible result or object by use of the model. And some of those examples of controlling a particular machine could be an AI-related model or algorithm, such as an autonomous vehicle that may have a trained AI model in it to detect objects for steering or for collision avoidance. Or you could have an AI-related model in a medical device, such as a syringe or a needle, where you're using the medical device to locate bone or something inside of tissue. These are all examples of in uses of a particular AI-related model. And that's actually it for that section. The next section will have examples showing you how that strategy is successful per examples provided by the USPTO itself. And real quickly, a quick primer on some of the law that the USPTO is using. And I won't bore you with the details, but basically there was a 2019 patent eligibility guidance that came out in 2019, very early 2019. And what this guidance did was attempt to provide guidance to its examiners of a very difficult case that came out by the Supreme Court in 2014 named Alice versus CLS. There may be people on this call that's familiar with Alice, but if not, Alice is basically a case that dealt with computer-related technology and whether or not that technology was related to an abstract idea. That was a big question. And since that case, basically all computer-related inventions, including AI, since AI is a computer-related invention, get scrutinized under this Alice test, which asks whether or not a claim is directed to an abstract idea, and if so, then whether or not that abstract idea is something, quote unquote, significantly more to demonstrate an inventive concept, which are all legal words and legal terms, but what the court is really getting at is that they want the claim to be technical enough to show a practical application of an idea rather than just claiming the abstract idea itself and preempting others from using the abstract idea. And I'll give you some examples of that in a moment. And here are some examples of abstract ideas. So some of the things that the courts are looking out for to make sure that are not claimed and taken away from the public domain or other inventors to invent is categorized by the 2019 eligibility guidance. And there are 3 broad buckets, as you can see on the left of this table. The first one is mathematical concepts. So if your patent claims have in them some type of mathematical concept, your patent application will most likely be identified as an abstract idea. And a mathematical concept you can think of as A really good example would be E equals MC squared, which is a famous example by Einstein. If your claims have that level of detail in them, they'll most likely be flagged as an abstract idea. The second one, and that's most common, and the one that was actually at issue in the Alice case, was certain methods of organizing human activity. When we talk about certain methods of organizing human activity, we typically think of business or financial type claims. For example, what was at issue in Alice was the idea of hedging and mitigation of risk. So the claims in Alice directed towards using a computer to hedge or mitigate risk, and the court said that that was abstract because it was common and well known that to use in order to hedge or mitigate risk, and you can't just say, I'm going to do that on a computer and claim that and take that out of the public domain, because that claims that concept in an abstract way. And according to the court, they did not want those types of inventions, precluding everybody else from practicing these age-old techniques of certain methods of organizing human activity. And then finally, the last category is mental processes. And these are concepts performed in the human mind. It's very similar to certain methods of organizing human activity. Basically, if an examiner or court can argue that your patent claims are not technical in the sense that a person could perform the same thing that you're trying to claim on a piece of, with a pencil and paper, or in their mind alone, without any technology involved, then you could get, your claims could be also considered to be directed towards an idea and found ineligible. In all cases, if your claim is directed towards an abstract idea, it is possible that either the court or the patent office could invalidate your patent or not give you a patent in the first place by denying your application. So that's the risk, and that's kind of the game at issue with all software-related patents, including AI, because AI, again, is squarely within the AI-related case. So with that backdrop, I'll jump into the 2019 patent eligibility guidance, which had several examples showing how you could patent computer-related technologies, even in view of the Alice decision. And one of those was example 39, which happened to be related to AI. In fact, example 39 was related to training a neural network for facial detection. You can think about unlocking your iPhone or whatnot like that. It's the same type of technology. And what you're seeing here is an example hypothetical claim, which is example 39 for training a neural network for facial detection. And what the patent office said is that this claim is in fact eligible, even under the Alice test. And what I've put here on the right side is the 1 and 2, and these are the same features that we talked about above. That you can include in your claim language to demonstrate that your AI-related invention is in fact patent eligible. So here, as the first step, we see a training set of data. So you have a training set, and in this particular case, you have a training set of digital facial images. And in the second step, you're going to use those training images to train a neural network. And the neural network is going to be used for facial detection. The last few sets of elements are just updating the training set in order to make it more intelligent by weeding out deficiencies in the first training step. But the important point here is to see that those first 2 steps are present: the training data set and then the training of the model itself. And what you're looking at here is the Patent Office's own chart where they go through the analysis. And what you see on the left is all of the different steps that the Patent Office will go through in order to determine whether or not a patent application is eligible or is not eligible under the Alice test, which starts off with step 1 and then jumps into the all-important step 2A. And so what they do is they ask under step 2A, is this directed towards an abstract idea? And they go through those three different categories that we just mentioned: mathematical relationships, certain methods of organizing human activity and mental processes. And they say that no, the claim that we just saw is not directed towards any of these things. First of all, it doesn't have any mathematical relationships in the claim, so it's not directed towards any mathematical relationship. It's not directed towards any type of business or finance, so it's not directed towards certain methods of organizing human activity. And finally, you could not do this on a pencil and paper or in your mind, because you have specific computing steps that are using a deep neural network in order to perform image-based analysis on pixels. And so that's not something that humans do in their mind. And so therefore, it does not fall into one of those three categories. And because of that, the analysis ends there, and the patent is eligible according to the USPTO. As a real life example, and that was just a hypothetical example provided by the USPTO, there is an agency or tribunal called the Patent Trial and Appeal Board, which is at the USPTO, and it's comprised of patent judges that are attorneys. They have experience as attorneys, and they act as sitting judges, and they hear cases about patents. And in this particular case called Ex parte Hanan, there was an AI-related patent at issue that the examiner had rejected. The applicant appealed the rejection. So if you get a rejection at the patent office, you can appeal it and ask the PTAB, as we call it, the Patent Trial and Appeal Board, for relief. And that's what the patent applicant and Hanan did. And what you're looking at here again is is claim 11 of the patent application, which is illustrative. And claim 11 is about systems and methods for improving the transcription of speech into text. So it's a natural language processing type of AI invention. And again, we see the same 1, 2, 3 pattern that we described before, where you have a set of training samples used to train the model. So there's steps 1 and 2. And then finally, we have using the predicted character probabilities, or use of the model, in order to determine the natural language speech over on the right. And so what the judges did, and there's a panel of 3 judges making the decision, they performed a similar analysis, just what the USPTO did in example 39. First of all, they saw that the claims did not recite a mathematical formula. There's no E equals MC squared or similar formulas in that claim. They also said that it did not recite a mental process. The steps cannot be formed mentally in the human mind. And then they said that, not surprisingly, translations from text into speech is not a method of organizing activity, human activity, because it does not include any type of financial relationships. Instead, going back to the top of the slide, it was directed towards deep speech learning and a trained neural network, which actually provides an improvement to the underlying machine in order to make traditional methods of speech methods much simpler, which is a way to show an improvement to machine. If you can show that your process that you're claiming improves the machine by making the machine have to process less data, or process it faster by means of reducing the complexity of the algorithm, that is a great way to demonstrate an improvement for purposes of showing patent eligibility to the patent office. And then finally, and this is actually my last slide, so I'll finish it up and we can jump into Q&A after this. There are other legal forms of protecting AI-related IP. And this is the only slide that I included on them, just because these types of AI of IP, while important, are less talked about, at least by myself, than patents. Although they are talked about in the transactional space when you're buying and selling companies, let's say in the mergers and acquisition space, because this type of IP would of course be part of any type of deal or transaction, one of which is copyright. Of course, the AI, the data used to train an AI model is very important, as we know. Anybody creating an AI-related model needs data to do so, at least in a supervised setting. And so a supervised machine learning type setting. And so this data would be subject to copyright upon being fixed in a tangible form. So would an AI model, by the way. Once you train a model with its different weights, it too would also be subject to copyright, because it would be something that's creative and that's quote unquote fixed in a tangible form, which is the requirement for copyright. And then finally, AI algorithms can be entitled to trade secret protection as well. Trade secret protection, there is a federal or national level protection now. There's also state laws that protect trade secrets as well. And protecting trade secrets typically involves having a company policy where you keep those secrets, such as the AI-related algorithm or how it's trained, a secret. It's confidential within the company itself. Usually there's some restrictions around the AI-related technology, such as who can access it, is it secured behind a server in a particular data room, and things like this. And if the trade secret is protected in that manner and not publicly disclosed, then you enjoy trade secret protection, or you can enjoy trade secret protection on that AI-related technology. So with that, I'll end the presentation and just say thank you for everyone listening, and happy to open it up to questions.
Thank you, Ryan. I had to go off. My boyfriend came in, and then my daughter came in, so I went off the video. But I know we have a couple people on the call. I think we had that other question as well. I forget what member it was, but I don't think she joined us. But I was wondering if you could talk about her question. I had it up and now I have to pull it from my phone. So we'll ask everyone on the call if they have any questions. Otherwise, if you could go into answering that, I think that would be great. And I'll look for.
Okay, I see that there's one question, I think, to Sean about the simplicity or lack thereof of trade secret protection. I'll just say that it's not quite that simple. I suppose it may have sounded like that. Really, the complexity in trade secrets is the longevity in keeping it secret. So, like I mentioned, usually companies have policies in place that are distributed throughout the company to all employees, and that policy informs the employees that at least need to know that if you're going to access a particular trade secret artifact, such as like AI or a document, or the Coke formula is usually the best example. If you're going to access that, then how do you access it? Where's the particular trade secret, such as the AI algorithm or data, kept? What do you have to do to access it? Is on a particular computer? Are there passwords? Do the passwords change every day, year, things like this? And so it's the policy to protect, let's say, the Coke formula can be incredibly complex, even though, let's say, the Coke formula itself may not be complex itself. So there are requirements under the law, and it differs state by state. But the usually what cuts across all of the different requirements for trade secret protection is that you must keep it quote unquote secret and not public, and it can't be easily accessible to people outside of the company. And so if you have policies in place to secure that information, that is, I guess it really is that simple, but the policies to protect can be quite complex. So I'm not sure if that's a good answer, but it is an interestingly complex area of the law. And usually there's a large legal document in place, such as trade secret policy, to secure that secrecy over a long period of time.
Hey, Ryan, this is Christopher. I got another question. In the AI space, if a human is defining the hyperparameters and providing the training data and stuff, does that make them eligible for, as an inventor, in the when they try to patent a an AI algorithm?
If they provide the data, in order to be an inventor in the eyes of the law, you have to contribute to the conception of at least one claim element. So if you as an inventor or as a person say, I want to train an AI model and that AI model has to have data A, B, and C, and that a claim element with A, B, and C goes into the patent as part of a claim, then yes, you would be considered to be at least a co-inventor on that basis.
Thank
But
you.
if you're just supplying the data, let's say if somebody else asks you to give you a whole data set and you have no idea or why is this person asking me this? You just provide a data set, then that of course is an example of you not being an inventor. You're just providing the data to somebody else who supposedly is an inventor that has the idea to use that data for a trained model.
But if you're making some decision on the features that you're providing in the data, is that what qualifies you as contributing?
If that feature is in the claims, then yes. If you have it's all going to come back to the claims. Is what the patent claims claim, is that your idea or not? If it is, you're an inventor. If not, then you're not.
Ryan, Sean had a follow-up question and then James has a new one. So I'm gonna read both just to make sure we get to them. But Sean's follow-up question before Christopher's was, do you define the code as the trade secret or the packaged file? And then James asked, can the final weights of a trained model be patented or copyrighted or both? Could someone avoid infringement by implementing a minor change in weights? Can one obtain royalties by others using such weights? So that's in the chat when you want to address both, but that follow-up question from Sean and then James.
Okay, yeah, I see the one from Sean. So I'll just read it again. Do you define the code as the trade secret or the packaged file? I'll assume that the code is the code such as like Python or Java or something like this. I mean, certainly that would be the code if it's, let's say it's written down and, it's executing on some server or something like that, and it's stored, somewhere secret, then absolutely. We have discussions all the time about whether or not someone should in fact patent a server code, because the server is, of course, it can be kept secret behind a company wall, and no one will necessarily see the code running on that server. So the question becomes, gee, do we really have to file a patent on this? Can we just keep it secret? And usually the answer to that is, well, do you have, what's on the other side of the server? Is there like some client device that's hitting it that has a GUI that would make the code running on the server at least, not secret? Like, how much, what code on the server is in fact hidden and not seen? And so those kind of questions come about. And if, the server is not really doing that interesting, and the more interesting thing is happening on the client device with which the server is communicating, then, it's a better candidate for a patent, because somebody could take the client code, presumably, let's say an iPhone app or something like that, and deconstruct it, and therefore your secret is no longer a secret because it's public. And so, yes, the code can be a trade secret. The packaged file, I would assume that would be the code just in a file and not executing on the server. Sure, that could also be, a trade secret, stored in a secret place, just like the code executed on the server, so running in real time. And going on to the next question, can the final weights of a trained model be patented or copyrighted or both? Both, actually. So you can train a trained model, and you could actually mention the trained weights in the patent itself, and that could become part of your claim. It'd make it a very narrow claim, but you could do that. You certainly put it as a dependent claim set. And can it be copyrighted? Yes. I mean, you could put your your copyrighted model into it could be copyrighted because it's going to be something that's it'll have a modicum of creativity. It'll be recorded in a tangible medium of expression, which are both of the requirements for copyright. Could someone avoid infringement by implementing a minor change in weights? Again, if your patent claims are drafted so narrowly that it requires a specific weight, then yes, you could avoid infringement. Typically, patent claims, including the examples that you saw tonight with Claim 39 and the one from the Hanan case, as you saw, those did not mention weights whatsoever, and those are usually how they're drafted. So that avoiding infringement by changing weights probably for most AI-related claims will not save you from that. And can one attain royalties by using such weights? Yeah, absolutely. I mean, if you come up with a model and you're able to patent that, and let's say those particular weights, are the best and gives you the most accuracy that nobody else can achieve, then someone may pay you for those particular weights. Again, that would be a very interesting case where you're able to get a model with specific weights that no one else can, simply train a different model with slightly different weights and get. But yeah, in that hypothetical, if you do that, you could certainly have a valuable patent where you could get royalties from other. Probably unlikely, but it's possible.
I want to make sure, James or Sean or Christopher, if you have any follow-up questions to your initial ones. And maybe, if you're thinking or you want to ask anything, Daniel and Eric, I'm putting you on the spot a little bit. But since we know this is going to be posted, this is slightly a little bit more of your subject matter expertise. Are there any questions you think our members would want to hear about? Anyone who's like hopping onto YouTube, or something that we might ask Justin to ask during the his podcast reporting, or and
Sure.
it's okay if you don't, but I thought I would be like, let's cover all our bases while we have Ryan.
I have a question that sort of builds on what James asked in the chat. When we look at state-of-the-art AI models, what we see are basically three pieces. First of all, you have a training algorithm. Obviously, that's a software algorithm. I imagine it's already covered adequately under software patent law because it's just an algorithm. Then we've got input data to the training algorithm, and then we've got the output of the training algorithm, which is the weighted model. And then you have to have some kind of imputation algorithm at the end to apply the trained model to do something. So if you look at something like GPT-3, they've taken training data, thousands of gigabytes of training data from all over the internet. You can't patent that or copyright that because it's just basically stolen from other sources. Then you have the training algorithm. You can patent that because that's software. Although I don't know if they specifically can patent it because a lot of it is based on academic research. And then that third part is the automatically generated weights, which may have cost them, there's some estimates that it cost them $100 million to generate the trained weights for the GPT-3 model. So it's a very valuable resource. So what seems novel about AI compared to other parts of software is really that trained model is super valuable, independent of the algorithm and independent of the input data. And I guess my question is around how do you incentivize people to create those models? How do you protect those models? You could keep them as a trade secret, but that's not really desirable. We want everyone to be advancing the state of the art and sharing these models. Fortunately, most of them are shared right now because this stuff is still in the early stages. So a lot of it is being done by sort of academic institutions or nonprofits. But going forward, how do we incentivize people to create AI models and allow them to still be used and licensed and protected?
Yeah, thank you for the question. I mean, hopefully one of the incentives is the patent system itself. If you do, in fact, get a very useful model that's costs many man and women hours and money to get, then you could certainly patent that with its specific weights like we discussed, or better yet, you would patent it at a more generic level and then have a dependent claim that patent various of the weights that's inside the model, and then you could license that out if that was the question. If the question is like, how can we distribute this or make this more available to other people, then you could talk about possibly patenting it and then providing a standards body to those looking to license it. There's all kinds of other patents out there in the world that are called standard essential patents. One of the most one of the widely recognized one is what's on like MP3s and JPEG technology. There's all kinds of standard essential patents on those, and so anybody that wants to create an MP3 related device or something like that has to get a license, but the royalties on those are very low. In view of the fact that everybody wants to use them, but that's basically a consortium of groups like Toshiba and Sony and stuff like that own like these patents, and they make them low cost for creators and developers to license them for use of these important technologies. In fact, that's why we probably are all using MP3s and these various file formats, is because they are either free or cheap enough to do so, and that's what incentivizes others to do it. And a final thought is, since this is software, let's say somebody creates a great model and puts it out there for the world to use. There's open source licensing that can be used as well. So you could put out, your model, pursuant to an open source license. Let's say it's a copyleft type license like GPL, and GPL version 3 or 2 or 3. That would become a sticky license that would apply to use of that model going forward. Of course, there wouldn't be a lot of money or incentive for that, because those types of licenses usually provide the underlying software for free. If you're a developer such as myself, anytime you download like a package or library or something like that, let's say Python, you're usually looking at all kinds of open source software licenses, like from MIT and GPL and blah blah blah. And so those types of things could be applied to an AI related model, given that it's software, if there's an interest in making that model free and available for others, and not so much making money off of it. So there's all kinds of legal tools that one could use based on their given underlying interest for sharing that model.
Thanks, Ryan. I actually have one more follow-up question, and that's also pretty much related to the previous question, which is, before when I was working in commercial software, I actually work in open source now, but before when I was working in commercial software, one of the key criteria for us to patent something was that if a competitor had used that patent, we would be able to know. So if we were patenting an algorithm and that algorithm only made sense to run on some cloud server that we would never have access to, that patent would have no value for us, because we would never even know if anyone was infringing. And of course, maybe the competitor would know, maybe they would accidentally infringe. Doesn't really matter practically, because we wouldn't have that information. In AI, because it's a black box, because you have this trained model, and you have no idea how that model was generated. GPT-3 has written a paper about how they generated their model, but they don't say all the details. And also they made that paper out of the goodness of their hearts. They could have kept it all secret and just released the trained model. So as software becomes more of a black box, as you're getting some model that might be 10 gigabytes of model weights, and you have no idea where they came from or how they were generated, how does a patent on the AI technology used to train that model have any value?
Yeah, so that's
or how would you demonstrate that someone is infringing?
Yeah, and it's a great question. And actually, you'd be surprised that lawsuits get filed all the time for these server-side technologies that you don't have the complete picture on. I litigate myself, and let me give you an example in the client server world. So, back in 5 years ago, there was a lot of lawsuits filed against SSL, which is secure socket layer technology, which as you probably know is computer technology using public-private key encryption for client servers. And so The interesting thing is that a lot of these patents read on these client server technologies using SSL, where some of the claims you would have no idea whether or not the potential infringer was doing it on the back end, because at least half of that public key and private key encryption was happening on the server end. And so what the plaintiffs did was they looked at the client end and found that, hey, at least some of the claim elements on the client side are doing things that we believe, would implement the invention on the server side, the stuff we can't see. So you can, in the US, file a case with the court and say things like, and show the court screenshots or whatnot like that of what's happening on the client end, and then also say, upon information and belief, I believe this stuff is happening. This other stuff that I can't see is happening on the server end. And that's what they did. And what this does in the US is allow you to get quote unquote discovery, which you can ask the opposing side to show you their source code. In fact, I have been in many lawsuits where they will send me over, because I have a computer science background, right? And they're like, Ryan, take a look at these guys' source code and let me know if you think that they're in fact doing that secret stuff that we can't see. And the other side will have to do it by subpoena under a court. I will go over to usually an opposing law firm's law offices, and they'll make a laptop or computer, typically air-gapped, available to me, or my source code expert, which is usually a professor at a university that teaches computer science. And we'll take a look at the software source code in private in that room, and see if we can see that there's infringement that lines up, the source code lines up with the claims, which shows infringement. That I provide that example because it could also be done for AI. Let's say if you have an AI related application, or on the front end of that application, the output, you can see something that's being done either on a client device, or maybe there's marketing materials. You mentioned GPT-3 put out a publication. What if I had a patent on something that GPT-3 did, and I read their publication and they're like, my patent does something very similar to that. I could take that publication, file a complaint into a court and say, look, this is what GPT-3 said that they did. My patent's very similar. Upon information and belief, I think that they're infringing my patent. And then all of a sudden I'm in court, I can file a subpoena against them and go look at all their source code and then figure out if they're doing that on the back end or not. Again, I've been in cases where I've been on the receiving end of that, where people have come over and use that same technique on my clients, where they want to see our source code, and they've come in, they've looked at it, and we say, here's our source code, take a look. You will learn that we are not doing any of the stuff that you think we're doing. And then they do that. They usually depose a few of our source code developers, and we are able to demonstrate that we're in fact not doing that, and the case ends and goes away. But in the US, under this deposition and discovery system that we have, it's quite common to have these cases where you can actually get and see the source code of a company that you believe is in fact infringing your patent, even though you can't see it by Google search or something else. So.
Great, thank you. That's a really comprehensive answer. Eric, did you have any questions? Oh, is Eric still on the call? Yes.
I don't.
Eric's also in engineering. Okay.
I don't. Ryan, you did an awesome job, and especially covering the questions that have been asked after your presentation. So thank you so much for sharing your time with us this evening. We appreciate it.
Yeah, absolutely. Thank you guys for the questions. I can't tell you about how much these same types of questions come up. The discovery side. How can you detect this stuff? If it really is running on the server. A lot of these questions are very common, and so it's fun to talk about. They're important questions, and certainly sophisticated questions from an audience that understands the technology. So happy to answer it, and happy to be here with you guys tonight and provide this info. So thank you for having me. Yeah,
Thank you again, Ryan. I will just relay that sentiment as well. I will stop recording right now.